none. Senator Sweeney, do you have a committee report?
I would like to wait just a little bit. Can we go to the next bill?
Yes, we can.
Thank you.
Yep. Senate File 2344, Senator Dawson, do you have a committee report?
I do, Mr. Chair. Your subcommittee of Dawson, Kidding, and Whiting recommend passage.
You're in order for opening comments.
Thank you, Mr. Chair. This bill comes as a result of State versus Albright last year, and is my best attempt at doing Lester Hickey's duty as substantive code editor cleanup bill. This bill here makes changes to the assessment of fines, fees, and surcharges, along with attorney fees and court debt to the overall system. There's going to be some additional changes needed for this bill here. We're still busy on them. We're receiving some more feedback from the invested parties in this. And that concludes my opening comments.
Are there any questions? Senator is now in your order.
Thank you, Mr. Chair. I just want to thank Senator Dawson. We still haven't hit the end of the road with this, but you know, he's spending a lot of time, and it is complicated, and to keep all the parties happy and fiscally sound isn't going to be easy and may not be attainable, but I do appreciate the extension of your time and your
Senator Lowe, your order.
Yeah, thank you, Mr. Chair. If Senator Dawson would yield, we have had an amendment distributed. Is it not your intent to offer that amendment to committee?
Correct. There was a huddle while we were in caucus. The amendment, the intent of it, I think we need one more sentence in there. So I've got to withdraw the amendment and correct it for floor amendment.
Thank you.
Any other questions? There being none, Senator Dawson, you're in order for closing comments.
Thank you, Mr. Chair. While I said I was trying to do an attempt at the LSA, I probably should get the LSA some credit here. Joe McInerney behind me, because the good idea of Harry's flow fast and furious to his queue, and then there's always corrections, and I'm sure he loses his patience a lot of times, but I do want to give him credit here for sticking with us and hopefully make a good progress. So with that being said, I would move the bill.
Short form has been requested. All in favor say aye.
Aye.
Opposed? This bill will pass the consent calendar in Rule 40. Next bill up is Senate File 2293. Senator Dawson, you have a committee report.
I do, Mr. Chair. Your subcommittee of Dawson, Kinney, and Shipley recommend passage.
You're in order for opening comments.
Mr. Chair, passage with amendments. My opening comments here, this is the Peace Officer Bill of Rights. We've been probing this issue for a few years. This will make changes to this specific provision of the code. We had a really good subcommittee yesterday, and I've been collaborating with Senator Kinney quite a bit on this here. We do not have an amendment ready today. I think we need to work on this over the next weeks, or a couple of weeks here. I think it's a good game plan going forward, maybe find some resolution on this. So I would just say that this is brought to us by multiple law enforcement entities out there. This is not final form, but I still we can get to a bit interesting conclusion on this.
Are there any questions? There being none, you're in order for closing comments.
I support the bill.
Short form has been requested. All in favor say aye.
Aye.
Opposed? This bill will move to the Senate calendar under Rule 40. Senator Sweeney, are you ready? Okay, Senator Sweeney, do you have a subcommittee report on Senate Study Bill 3081?
Yes, Mr. Chair, I do. Signed by Sweeney and Whiting, recommends passage. Senator Bisignano did not sign.
You're in order for opening comments.
Thank you very much. This is a bill to looking at protecting 16 and 17-year-olds from predators, sexual predators. And it's a person who engages in sexual activity with another person who is 16 or 17 years of age and is guilty of an aggravated misdemeanor. That's the end of my opening comments.
Are there any questions? Senator Bisignano, you're in order.
Thank you, Mr. Chair. This bill came up last year. And this is a really unusual bill. And I don't know why we breathe any life back into it this year, but we have. I haven't, but you have. We have an age of consent in this state, and I don't think anyone in this room doesn't understand the definition of the word consent. And when you take a word like consent, and now we have built fences around it with caveats of you can't do this or you can't do that. I'm really concerned, Senator Sweeney, that you called people who today are legal under the current law in the age of consent, that your terminology that somehow we're stopping sexual predators. Well, now they become sexual predators who today, or if this bill would pass, and I sure hope it doesn't, and signs into law, you're fine today and you're an upstanding citizen, but if this is signed now, if you fall in this category of these stipulations to the term consent, you're a predator. And I see where you have softened the blow from a deep felony to an aggravated misdemeanor, but you still have criminalized something that's been legal in Iowa for, I don't know when this was passed, but I would assume decades. We're talking about 16 and 17-year-olds who would have consensual sex with people who are 27. And it could be a male. It could be a 17-year-old male who has consensual sex. May be having consensual sex at 16 with a 26-year-old for a year. But as soon as that guy starts, when he hits his birthday, becomes 27. And so at that time, by law, they would have to stop having sex, even though they're in love, even though maybe they're engaged. Or they would be a sexual predator, and they would commit an aggravated misdemeanor. And at 16 is the age of consent to get married with your parents' approval. So the parents' consent is not stipulated that if the man is a certain age or the woman is a certain age, they can consent to let their 16-year-old marry a 40-year-old. We don't have any problem with that, and that guy's not a sexual predator. I mean, when you think of the contradictions in this bill, I mean, first, without going into great detail of the nexus of this bill, which really ought to be on the table, but we're not talking about it. Maybe it was an unfortunate situation, but I assume it was consensual. And, you know, parents are parents. I know that people marry outside their age range of maybe what their parents find acceptable. But when you reach the age of consent, then we accept it as parents and we go on. This is very punitive. When you play with the numbers of ages and birthdays and so forth, you may just hate this guy who's 27. Maybe he's 30, they just haven't had sex. But on your daughter's 18th birthday, they just tell you, hey, I'm headed to the motel. You're not gonna like it any less because she's now 18 by one day, but she's still with the same guy that she is in love with or wants to have consensual sex. And Iowa has to decide what age do we want consent. It's easier for me to accept if we make the age of consent in this state 18, bit a lot, but Iowa, has chosen to be odd in a lot of different areas. Why not change it to 18? Let's don't create a category of sexual predator of someone who may have in love with your son or your daughter and been having sex with them for a long time, but hits his birth date and all at once, he's a predator. If you want to lose connection with your children, and Senator Garrett and I have been through a number of the subcommittees on grandparents' rights, well, I can guarantee this would be one of them, where you probably never see your grandkids, probably never talk to your kid again, because you just took the love of their life, put them in jail, called them a sex offender, and put them on the sex offender registry, which limits where they can live, whether he can work, all the things negatively that why would you want to do this? This is a bill sent by a member of your party over one situation in their district. And we are going to now change the course of Iowa and all of its ramifications that make absolutely no sense and going to create hardship on many, many people. I mean, we don't know the day this is signed how many people have to break up or have to hide. They're out there, obviously they're out there. I've never seen a situation like this. We're going to pass a law that's going to require people that are responsibly in love to break up. There could even be a child involved. There could be a child involved. And we're going to make that person a criminal, sex predator. I don't know what all comes with it. If a restraining order comes, can he not visit his family? All those need to be thought about of what comes out of what we are doing, because everybody understands consent. But when we set, and why is 27? Why not 25? Why not 30? It's an arbitrary number on an individual situation that is going to change the course of people's lives. And I don't know why we're doing this. I can't even think of a good reason to jump on your side just for the sake of argument and help you out on this. I don't know how everybody else feels here. I would assume it's here. You're all going to vote for it. But you heard my arguments. You heard the scenarios. There could be children involved already. And we are now making that couple, even though they might not be married, we're making that an illegal situation. And that child's going to suffer. And that man is going to be a predator. And his background is going to show it. And his employment is at risk. I don't get it. I don't know what we're trying to accomplish for why. I know who. I don't know why. And with that, I wish there was some discussion here because I want to hear it. You owe it to the state of Iowa, to people that are in this situation that might have children that now is going to label their father a sexual predator, that he can be convicted as an aggravated misdemeanor because the disgruntled father can press that charge. The child's prima facie evidence. So it's not a matter of denial. What are we doing? Is this one that could be thrown in the heap and say, no, we got bigger and better things to do? The Iowa legislature and the Iowa Senate? I think we do, and I think this is an example of carrying water for each other's proposals that sometimes you gotta tell, like your child, no. No. Sorry, we're not carrying this. This has too much ramifications for human beings across the state and turns our consent laws upside down. Thank you, Mr. Chairman.
Are there any other questions? There being none, you're in order for closing comments.
Thank you very much, Mr. Chair, and thank you very much for your comments. One thing I do want to clear up, this is not putting the person on the sexual registry. So, just to let you know that part. And also, with this, what we're trying, or what is being tried here to do, is to, we have this situation where people are grooming people, young girls, and when they turn 16 at the age of consent, then the person knows. In the state of Iowa, we have the person, right now in law, that they can, the person can groom them, and when they turn 16, they can have sexual relationship with them. That's fine, but if they send a pornographic picture to them, it's against the law. But to have sex, it's okay, but to send a picture, it's against the law. So I would like to work on this in the interim to see if we can maybe come to an idea that we can, kind of curve out this a little bit. But this is what we are trying to do with this. So thank you, Mr. Chair.
Short form has been requested. All in favor say aye.
Aye.
Opposed?
No.
Senator Peterson, Senator Hope, Senator Taylor, Senator Bisognano, Senator Kinney. This passes under the Senate calendar under Rule 40. The next item up is SJR 8. Senator Whiting, do you have a committee report?
I do, and thank you, Mr. Chairman. The subcommittee consisting of myself, Senator Chapman signed. Senator Kitty was also there, but politely declined to sign.
In order for opening comments.
Yeah. Thank you, Mr. Chairman. So how this came about, this is an issue that I've been following and supportive of for a number of years. I spent about 4 years out working in the foreign country of Washington, D.C., and came across some language that federal bills that have been introduced to constitutionalize victims' rights. And so when I got to the Senate, this is a top priority for me to better protect victim rights, and so I introduced a constitutional amendment modeled after that. My goal in all of this is to level the playing field between the rights of the defendant and the rights of crime victims. We had a good discussion, I think, at the subcommittee on this, and one of the things that I point out is that while crime is prosecuted by the state, that is, when a defendant commits a crime, the full power and weight of the state come against the individual, we grant them broad constitutional protections, as we should. But most often, the crime is committed against an individual. And so what can we do then to ensure that those victims of crime have robust rights? So I drafted a resolution that had buckets of rights in there. We could just call them buckets or categories. The right to notice and to attend, to be heard, to be proceedings free from reasonable delay, reasonable notice of release or escape, and due consideration of victim safety, dignity, and privacy, and to restitution. We have a code chapter 915 that a lot of people tell me is good, and that some of our colleagues have been to other states and have heard is good. But ultimately, when a defendant's constitutional right conflicts with the victim's statutory right, the defendant's constitutional right is always going to win. And so with that, I introduced this constitutional amendment. However, that said, we do have an amendment, and I'd like to go to the amendment.
In order for the opening comment.
Thank you, Mr. Chairman. So I gave all that wonderful description and background on how I got to this language, and that's great. What we have now is going to this language, and for those of you keeping score at home, this one's a lot shorter. And what we've done is strip that down to a single sentence that says, "The rights of a victim of crime, as provided by law, shall not be infringed." Now, I'm not wedded to any particular set of words, but I am advancing a principle, and that is to constitutionalize victims' rights. One other piece, just to conclude my opening remarks on all this, is I also have a concern. We're having a sort of a broader criminal justice reform movement across the country, and I sort of share the term that I've heard Senator Cotton apply to it as jailbreak. And I have some concerns about that. And I want to make sure that not lost in this discussion on criminal justice reform is robust protection for victims, for crime victims. And that's not to discount any of the work that we've done as a legislative body over the years in getting to where we're at on 915, our law enforcement agencies that do this, and our members of the community that do this. But I think it's the right time to make sure that those rights are on an equal playing field, and that's why I introduced a constitutional amendment to drive that point home, to say let's not forget about crime victims in this process as well. And those would conclude my opening remarks on the amendment.
Senator Kinney, you're in order.
I'd like to thank Senator Whiting for bringing this amendment forward. This amendment does let us recognize that crime victims do have constitutional rights, and I urge my colleagues to support this amendment.
Are there any other questions? In order for closing comments on the amendment.
Well, thank you, Mr. Chairman, and again, as I said before, we come into the legislature, and we all represent the same number of constituents, and sometimes we have ideas that come from our constituents, and sometimes we have ideas that come into our own head from our own experiences, and this is one of those that is important to me, that preceded my time. We don't need to go into a belabored ment of the story, but I've also been a victim of crime. And we talked about this yesterday, and it was not any criticism or anything of the process, but I felt that we could have done a better job of notifying me on some things, like when this person was released. And so that wasn't a shot at county attorneys or anything. It's just a way to how can we better protect that, and I think this is one of those ways that we can do that. So I'm happy institutionally we're taking this up as the Judiciary Committee, and this is a big personal priority for me. So, Mr. Chairman, thank you for bringing this before the committee, and I would move the amendment.
Short form has been requested on the amendment. All in favor say aye.
Aye.
Opposed? We're back on the bill. Is there anyone who would like to speak on the bill? Senator Taylor, you're in order.
Thank you, Mr. Chair. Eventually, are we just going to put everything in the Constitution? We just can't keep adding volumes to the Constitution. Pretty soon it'll look like our law books, and instead of having this many law books, we'll have a lot of law books or Constitution you can't carry with you. I think we have pretty good victim rights laws right now in Iowa, probably some of the best in the states. And while I do appreciate the idea, at some point we're just going to have to say we just can't keep adding everything to our Constitution. Thank you, Mr. Chair.
Any other comments? You're in order for closing comments, Sir White.
Thank you, Mr. Chairman. And it is a good question, Senator Taylor. Does this need to be added to the Constitution? And maybe we do. Maybe we have the best victims' rights chapter of code in the entire country. But again, as I said in my opening, whenever a defendant's constitutional right conflicts with a victim's statutory right, the constitutional right's always going to win. And so the purpose of adding it to the Constitution is to afford these rights the same level of legal protection and enforceability, and ensure that when there's a conflict, one doesn't trump the other, but that we find an appropriate resolution through our legal systems. With that, Mr. Chairman, I'd move the resolution as amended.
Record's been requested.
Senator Zong.
Yay.
Senator Garrett.
Yay.
Senator Kinney.
Yes.
Senator Bizignano.
Yes.
Senator Chapman.
Aye.
Senator Dawson.
Aye.
Senator Hope.
Yes.
Senator Nunn.
Aye.
Senator Peterson.
Aye.
Senator Schultz.
Aye.
Senator Shipley.
Aye.
Senator Sinclair.
Aye.
Senator Sweeney. Aye. Senator Taylor.
Aye.
Senator White.
Yes.
Okay. This passes on to the Senate calendar under Rule 40. The next bill up is Senate Study Bill 3184. Senator Nunn, do you have a committee report?
Yes, Mr. Chair, your committee of Nunn, Kinney, and Whiting recommended passage.
In order for opening comments.
Thank you, Mr. Chair. This bill looks at establishing a process for the collection of sexual abuse kits that would be used within our criminal justice system, particularly within the Criminal Victims Assistance Division of the Attorney General's Office. We've been very grateful for the AG's office bringing forward a process in which to both identify, maintain awareness, track, and then be able to recall sexual abuse kits when they enter into the system. As we all know, frustratingly, in the past, we've had a long backlog. This process is part of a federal pairing that would present us with a tracking system through barcode that would afford both the county attorney or the attorney involved in the case, as well as the victim and the person handling the kit, the ability to track and identify where that is throughout the entire process. Think of just like putting a certified piece of mail in and you scan, you're able to identify where it is in the process to its final destination. Here we afford the victim the ability of, in the case of rape, up to 10 years to be able to track where this kit may be and recall it in a timely fashion. Specific to this, we would also have the ability for the victim to maintain a awareness of where it is, change their password online at any time that they feel is appropriate or necessary for them without exposing any of their personal identifying information. With that, Mr. Chair, we take any questions.
Are there any questions? Senator Peterson, you are in order.
Would Senator Nunn yield to some questions?
Senator Nunn, would you like to yield?
Yes, Senator Peterson, I would.
Okay, that's a little too good for me. What is the storage time for rape kits in Iowa?
I would have to get that answer back to you. I know that we've improved, but I don't know what the exact time is now.
Okay, because under the legislation that we passed out of this committee, if that goes through, we'll have a different statute of limitations law, hopefully in place, that we may need to alter the storage. So I'd ask you to consider looking at how long. The other thing I'd like is for us to get some kind of data back on the results of the rape kits. It's my understanding we had 1,600 rape kits that hadn't been reviewed. And when they finally did review them, there was more than I think it was more than 260 were matched with people that were already criminals in the system, and there was a serial rapist that still has not been prosecuted. And I think that Iowans have a right to know which cases are being dumped and which cases are moving forward by county. If there's a serial rapist in your county, I think you have a right to know about it. And if your county attorney decides not to prosecute, Iowans should have a right to know. I also have concerns about what kind of data we're getting back on child rape kits. I requested data from the Department of Human Services on the number of child sex abuse cases over the past 4 years, and we had more than 2,600 cases that were founded. They're in every single one of our districts, and I think as a body we should have more knowledge about what's happening with these kits and know that they're stored and know what our local law enforcement is doing or not doing about it. And if they're not doing something about it, I think we need to be giving the AG some more authority to go after these predators. Thank you.
Are there any other questions? Senator Whiting, you're in order.
Well, thank you, Mr. Chairman. As I just got off my soapbox talking about constitutionalizing victims' rights, we have a bill that would help, I think, better protect victims' rights as well. And I was on the subcommittee, though I was in another full committee, wasn't able to attend. But I just wanted to thank everybody that put work into this, from the AG's office and the Crime Victims Assistance Division, for the work they do. And the other piece of it is, we have some opportunity for some federal funding, to come in and try to help kickstart this. And this is one of these issues that we see across the country, is that there's a huge backlog of these, and it's a darn shame. But if we can provide the resources and the data and stuff to track this, to help our law enforcement and our Attorney General's office and make this work to find the justice for our victims, that's very good, and that's why I'm happy to support it. So thank you, Senator Nunn.
Are there any other questions? There being none, you're in order for closing comments.
Thank you, Mr. Chair. Thank you, Senator Whiting, Senator Kinney, and Senator Peterson. You are exactly right. Being able to manage this situation first comes from having good information to operate off of. With the federal grant to the AG's office, we're looking at a 2-year runway to be able to set this program up statewide, and then a sustainability requirement here in the state of Iowa. So we have a responsibility to buy in with this as well. Being able to identify where the backlog is, where things are getting held up, is important for us. That starts with good data management, and I believe that's where this bill gets us. Making sure that the public is informed of what's happening is critical in the transparency of what we do as government. At no point, though, and I don't believe this is your intent, do I want to make things transparent that would ever put the victim in a position where their information or the status of their crime is being available to the public as they go through the court process. Or, in some cases, we've seen victims of sexual abuse may decide that they don't want to pursue a court case right now, that they are not in a spot where they can do it. And they have that 10-year window in which to come back and evaluate it. But we will always know where it is. We know the status of what is happening. I want us to be cognizant of the fact that when we talk about victims' rights, there's also the right to anonymity here. That this is oftentimes a very personal event. They should have access to it. We in the public should be transparent in our criminal systems working as they should. And I believe that's where you are on this. And would absolutely want to see a follow-on bill once we get this process to be able to make sure that we've got some transparency. But this gets us the data that we need to be able to move forward. So with that, I would ask for a good bipartisan vote on making sure our victims are taken care of. Would move the bill.
Short form's been requested. All in favor say aye.
Aye.
Opposed? This bill will be on the Senate calendar under Rule 40. Next bill up is Senate File 2292. Senator Dawson, do you have a committee report?
I do, Mr. Chair. Your subcommittee of Dawson, Kinney, Shipley recommend passage with amendment.
You're in order for opening comments.
Thank you, Mr. Chair. This is an officer-involved shooting critical incident bill. Again, as my earlier comments, it was a productive subcommittee. Parties who might have been on opposite sides previously are moving closer together, where there might be some consensus. But something again, where Senator Kinney and I are going to continue some discussions on the best pathway forward here. Continue my opening comments.
Do you have an amendment?
No, I haven't been ready for today.
Okay. Any other questions? You're in order for closing comments.
Something with the bill.
Short form's been requested. All in favor say aye.
Aye.
Opposed? This bill will move to the Senate calendar under Rule 40 as well. Next bill up is Senate File 2293 with Senator Dawson. Do you have a committee report? Okay. I apologize. Okay, I'm going to turn the chair over to Senator Garrett.
Thank you, Mr. Chair. Senator Long, you're in order for Senate Study Bill 3173, subcommittee report.
I sure do. Subcommittee made up of myself, Senator Kinney, and Senator Sinclair recommends passage.
Thank you. You're in order for opening comments.
Okay, this is a bill in regards to the sale of CBD products in the state of Iowa. There's some confusion right now with our law enforcement agencies. And what this bill does is try to clarify some of the confusion that's out there. This is a some legislation that was passed in 2019 by the state of Texas. And that will conclude my opening comments.
Questions or comments for Senator Zahn? Seeing none, Senator Zahn, your closing comments.
As we discovered that there is some problems with this bill, and we, Senator Kinney and myself, we've come to an agreement that we need to keep this process moving. So I'd ask everyone to support this bill, keeping in mind that we are going to have an amendment that will probably change this bill quite a bit. So I appreciate everybody's support.
Anyone vote? Short form's been called for. Those in favor say yea.
Yay.
Those opposed, nay.
Nope.
We have one no, and the bill is passed and move on to the Senate floor. Next is Senate Study Bill 3174 with Senator Zahn. You have a subcommittee report.
I sure do. I had a wonderful subcommittee made up of myself, Senator Dawson, and Senator Kinney, and they recommend passage.
Thank you. You're in order for opening comments.
This is a result of a meeting that I had during the interim with several chiefs of police in the central Iowa area, and it's in regards to the Brady's list. Right now, if you are an officer and you repeat yourself as a witness withholding exculpatory evidence, there's a list out there, but no one knows where the list is. Different agencies have it. To me, this is to protect the public in case there's a bad apple out there. And it also creates an interim study committee to look at this important issue known as the Brady's list. I'd be happy to answer any questions.
Senator Bizignano.
Thank you, Mr. Chair. I haven't had a chance to really look at this, and just trying to grasp a bill quickly through a bill explanation is not a good way to read a bill. But as I get this right, there are a couple of lists that talk about officers who have presented false evidence, testimony, so forth, and have to have defendants in the future be told that they're on these lists. Is that right?
That is correct.
And when an officer is placed on this list, are they defended at the time by the police association, the union, whomever, that they have their day to dispute their guilt to be on this list? There's this list just somebody, the chief or internal affairs, just to put Zahn's name on the list?
Are you asking Senator Zahn to yield?
Yes, I am.
Would you
Senator
yield,
Zahn, we
Senator
have
Zahn?
to yield. To answer your question directly, that's the interpretation that I have had from the meetings that we've had in regards to this. I will have to say, this is a complicated issue, and I think that's why it's really important to have a study committee in regards to this issue. There will be an amendment, if you looked at the study committee, where we're going to add the sheriffs as well. It is very complicated. There's just right now, Senator Bizignano, too much gray area in regards to if you're on the list or if you're not on the list. And every county does things different. And that's the reason why we're having this conversation. So I believe that it's in the best interest from a public safety perspective, as well as the officer that might be on this list or maybe might not be on this list. And what this does is just put sunshine on this list, is what we're trying to get to.
Because what I referred to, I know there was a great expose of this in the Des Moines Register that talked and explained about it. And if we're going to add the sheriff, it probably should be all sworn officers.
And that is,
DNR officers, everybody who's a sworn officer.
okay, I would be open to continue this conversation. There will be an amendment on this bill, and I'd be happy to sit down and talk to you and at least listen to all the proposals. Obviously, at the subcommittee, someone mentioned that they wanted just someone from the general public on this. I haven't decided yes or no on that, but there's no doubt that this bill needs some work. But I do believe I'd like to pass so we can keep the conversation going.
Thank you. I just think that this is a critical list for the public, the credibility of our law enforcement. And if we don't have that credibility where we can trust that sworn officers present all evidence and tell the truth when they're under oath, then we have a real breakdown in justice. And so I welcome this. Then maybe we should have it to where when you say you don't know where it is, nobody knows where it is, that if there is somewhere where it's posted online, to where the public, not just defense attorneys who are representing a client, but the public themselves know who is on this list. Thank you, Mr. Chairman.
Other questions or comments? Seeing none, Senator Zahn, in order for closing comments.
Our law enforcement people in the state of Iowa are incredible people. Every once in a while, there's a bad egg. And this is to protect the public. In the testimony that we've had in the subcommittee is that there might be a situation where a bad apple, someone in law enforcement, applies for some towns a long ways from the area that they've been accused to do this. So it's a public safety matter, as well as someone that might be on this list maybe shouldn't be on this list, and they don't know they're on this list. So really this is about having a conversation to clarify that and have really due process for that list. So I'd ask everyone to give me the benefit of the doubt that we'll continue this conversation. I'd love to work with you, Senator Bisignano, and support this bill.
Short form has been called for. All those in favor of the bill say yea.
Yay.
Opposed, nay. The bill is passed. We'll move on to the floor. I believe it's our final bill. It's Senate Bill 3059 with Senator Zahn. And we have a subcommittee report.
Yes, I do. The subcommittee made myself, Senator Bisignano, and Senator Shipley recommends passage with an amendment.
You're in order for opening comments.
This is a continuation of the 24/7 legislation that we passed several years ago. There was a pilot program that was operated in Woodbury County, and this is based on the feedback of what that is. What does this bill do? It changes the result of the data in the temporary restricted license, or known as TRLs, and the ignition interlock device. The 24/7 participants in the TLR, temporary restricted license, is what we're talking about in regards here. The bill associated, I'd like to go to the amendment.
You're in order for the opening comments on the amendment.
The amendment also provides, removes the tie between the TRL and the temporary restricted license. What we do is this is made up for people that have a high rate, a high number on their OWI or multiple OWI offenses. And what we're trying to fix here is the loophole with the temporary restricted license and close that loophole. This amendment removes the tie between, like I said, the TRL and the ignition interlock device. Whereas with this amendment, a judge may order participation in the program regardless of the offense, having a temporary restricted license. The amendment also provides that an offender cannot be removed from the 24/7 program until they provided proof to the law enforcement agency that they have installed the ignition interlock device. This is about public safety. That'll be the end of my opening comments.
Any comments, questions on the amendment? Senator Bisignano.
Thank you, Mr. Chair. I just want to add to this is there was the loophole really was that if you didn't get a temporary license, you weren't held accountable. And then we ended up with more people driving under suspension. And this will give the judge the option to put you in the program whether you get a temporary restricted license or not. So we're learning from this program that we created. That's a good thing. It's a good job.
Anything further on the amendment? Seeing none, your order for closing comments.
Well, thank you, Senator Vizcaino, for a better explanation than what I did. This is about public safety, and that'll conclude my comments.
Short form been called for on the amendment. Those in favor of the amendment, say yea.
Yay.
Opposed, nay. The amendment passed. We are now back on the bill. The senator's on.
I have no comments.
Any further comments, questions on the bill as amended? Seeing none. Short form's been called for. Those in favor say yea.
Yay.
Opposed, nay. The bill passes, and we'll move on to the floor under Rule 40.
That'll be the end of the hard work that this committee has done this week. I want to thank everyone here, especially our staff, Tom and Kathy, and especially the LSA people that are here. But most importantly, the people around this table, because you've done a lot of work. So I just need a motion to adjourn. Motion made by Dawson, we're adjourned. Thank you.